So moving further, under which section this has been framed? Under section 19 of the Foreign Trade Development Regulation Act. So section 19 of the FTDRA authorizes the government to make the rules. So the rules have been framed herein. See here. What is section 19? Power to make rules, right? And if we go to the end, here we have this is power to make rules. So here the central government may by notification make the rules for carrying out the provisions of the act, and then the list of the subject matters for which rules can be framed. So if we look at it this, what are the subjects on which rules are there? This is the manner in which the conditions subject to which a special license may be issued. So it is the rule number 3 is already there for the license, special license. The exception subject to which the person or class of person in respect of whom the fees can be levied on the manner in which. So as of now, there is no fees since 2015. So it is given in the rules. As per the rule number 5, there can be fees, but really as of today, there is no fees. The class or classes of goods for which a license, script, etc. is required under section 9. The form in which the terms, conditions subject to which the license, script, etc. can be issued. So all these terms and conditions we are going to see in the rules. The conditions to which a license, certificate, script, or instrument vesting financial assistance suspended or cancelled. This is also there in the rules. So all the subjects which are covered herein, those are there in the rules. Okay. So going back to the rules. No, we have come back to the same document. So here it is. So this is in pursuance of section 19. These rules have been framed. Who has framed the rules?
Central government.
The central government has framed the rules, and the name of the rules is called as the Foreign Trade Regulation Rules 1993. Okay. Now coming to this. What is the meaning of charitable purpose?
Without any commercial interest. No problem.
Here is the definition, and definition says includes, right? So just I'm giving you some interpretation of the definition. Whenever there is a word includes, this is called inclusive definition. And when you have the word means, this is called exhaustive definition, right? So when we have inclusive definitions, whatever is given there, and those are taken only as the examples, and anything, something comparable will also be deemed to be included therein. So charitable purpose includes relief of the poor, education, medical relief, advancement of any object of general public utility. Right. So as far as this definition is concerned, it doesn't talk about anything as far as the profit component is concerned. The purpose, ultimate purpose, what is going to be served by that will determine whether it is for charitable purpose or not. Right. So as far as Indian laws are concerned, it says that all the schools and colleges should be a non-profit organization. Are those really non-profit organizations? Show me any private school which is a non-profit organization. So here it is, when we say charitable purpose, so purpose is charitable, object is not the charity. Importer, exporter. Now here is a grammatical error in the definition. Just say importer, exporter means a person who imports or export goods or services or technology and holds a valid IEC granted under section 7. Now, what will you call a person who is holding importer exporter code, but he is not importing or exporting? Here is an error. They say who imports or likely to import or export. That should have been a much better thing, right? But that is not there. Anyway, licensing authority. Who is the licensing authority? To whom the rights have been given to issue the license. And when the right is given for the issue of the license, automatically the right to amend or rectify, suspend or cancel the license is automatically there with the licensing authority. Policy means the foreign trade policy, which is as per section 5, and section means sections of the act. Which act?
Foreign trade.
FTDRA, right?
Yes.
Because this will always be confusing. The act, so wherever we are reading the rules, that particular act. So earlier when we talking about that CBLR, at that time the act means it was Customs Act. In this case, the act means FTDRA. Special license means given as per section under section 8, subsection 2. Value means as defined under section 14 of the Customs Act. Meaning is given therein, but the determination of value comes under section 14 of the Customs Act. And then last, words and expressions used in these rules are not defined, but defined in the Act shall have the meaning respectively assigned to them in the Act. So means whatever definition is not here, it can be taken from Foreign Trade Development Regulation Act. So no important definition as such. Now this is a relevant grant of a special license. Reason for the background of the special license is already known. Under section 8, if the importer exporter code number has been suspended or cancelled, right? So this is where IEC granted to any person has been suspended or cancelled, right? So that suspension or cancellation comes under section 8, subsection 1. Then special license is there under section 8, subsection 2. The Director General, having regard to the following factors, grant to him a special license, namely. Who is giving that special license? The Director General. And why it is being given? Two important factors are here. These are two important factors. That the denial of a special license is likely to affect the foreign trade of India adversely. We are looking at the national interest. We are not looking at the interest of that party. Denial of a special license is likely to affect the foreign trade of India adversely. So if the export is subject to license and he doesn't have importer-exporter code number, then he cannot export. In that situation, a special license will be given to fulfill the obligation so that Indian national foreign trade does not get affected. Similarly, point number 2, that the suspension or cancellation of IEC is likely to lead to the non-fulfillment of obligation by India under the international agreement. So both the points are in the national interest. What happens to that party, that is subsequent. But if it is necessary that he should fulfill the export obligations and he should make it sure that the foreign trade of the country does not get adverse effect, then for that purpose only this license will be granted. And when this is given, this is certainly being given in the personal capacity to subsection 2. Subsection, these are number 1 and 2, these are sub points. Again, this number 2, this is subsection actually. So the special license granted to any person under sub rule number 1 shall be non-transferable.
So is the IAC code otherwise transferable?
Never.
No.
So then what is the need to mention, because it is always against the cancellation of our IAC. Is there a scope that it can be transferred?
There are certain things
Usually.
which are transferable, like a script is transferable.
Okay.
Right. So when it is specifically mentioned, then it becomes sure that it is also not transferable. Now, IEC. What are the provisions for this? Under which section this is granted?
Section 7. 7.
Of,
FTDRA.
okay. Then comes cancellation, suspension, right? Here we have two provisions. Section 8(1) and section 8(2). Compulsory for all commercial, not compulsory, all commercial imports and export of goods. I've intentionally mentioned goods. Because in case of services, what happens?
Only if you claim the benefit, then only you require an IC.
So in case of services or specified services, specified technologies, this is needed, right? So that also we can add. Let me pick up another color pen. For services, IEC is needed. If, now what else you will write here?
Any benefit taken under FTDRA or foreign trade policy.
Benefit under FTP. That is one part. Number two, is specified goods or services, and again specified technology. In all those cases, it will be necessary. So technology is also information only, right? So as such, that doesn't fall under the category of goods. So whether sharing the information, somebody requires importer, exporter, code number. If it is specified, yes. Right. So who is sharing, with whom it is being shared? So that government should be aware of that. Now, on what grounds this IEC can be cancelled or suspended?
There are three grounds. One is contravention of certain economic offense, and second would be it shouldn't be prejudicial
Prejudicial to the interest of the national interest.
Yes. And the third would be in case of misuse of any license for any specified goods, contravention of that particular. I think that's the third.
So here it is. Who has contravened any of the provisions of the Act or the rules and orders made therein by Central Excise Customs FEMA. Director General Officer authorized by him, reason to believe that the person has made export import in the manner prejudicial to the trade relations between the country and the other countries, or in violation of the international agreement, and any person who imports export specified goods or services technology in contravention of the provision. So in any of these situations, the license may be suspended or cancelled, right? So here I'm simply writing reasons. So add reason number A, B, C here. Pick up from section 8(1) and then section 8(2). In 8(2), this is in the event of suspension, and or cancellation of IEC. The person may apply for a special license. And a special license is Foreign Trade Regulation Rules 1993. On what grounds?
The denial will affect foreign trade.
Fulfillment of existing obligations, and everything is in the national interest. So, which may affect the reputation of India adversely, or for fulfillment of the commitments between two countries or international agreements. So, fulfillment of export obligations, and we can add the word in national interest. Now the picture is more clearer. Done? Any question? So what you can do is, if you draw the chart again, I have given you a separate chart for section 7 earlier. Incorporate that here. In relation to goods, in relation to services where it is needed, in relation to goods personalized and commercial, in relation to services personal and commercial, then exception to that. Right? So you can add that chart here. So it will become a crystal clear thing on one paper itself. Take a double spreadsheet and work it out. Can I clear this?
So why rules are made separately and why this act? I mean, are they made later? How is it?
No. You see, when the power has been given, any amendment in the act, how the act is amended?
By way of amendment. It's passed.
But where
Yes.
the amendment is passed?
It's in the parliament.
Parliament.
Bill needs to be
Right.
introduced.
And both the houses of parliament, then it goes to the president, then he signs it, right? And when the situations are fluctuating on a consistent basis, so the procedure and everything should change as per the requirement of the day. So when the powers has been drawn by the central government out of this act, only by issuing a notification, it can amend the rules. So whether it is schedule or these are rules or these are regulations, all three are done with the same objective. Right? Authority differs. Right? Regulations are framed by the respective department, rules are framed by the government, and the notifications are again issued by the respective department. Notification is also an extension of law. Schedules are made in the act because again the things of volatile nature are there. Right? So whenever there is anything in the volatile in nature, then for that is given either in the schedule or by way of notification or the rules or regulation, depending upon how the things are. Okay. So what is given in the act, which is not variable very fast, right? And we have one worst example of that. Worst example where things are included in the act. Any idea what is that? Monica may tell us. Monica. Worst example of any law. Income Tax Act.
Income tax. Mm.
Since 1962, every year hundreds of amendments and still loopholes are always there. Why to include so many things in the act itself? So that you are required to amend the act itself every year, hundreds of amendments every year. Why the law cannot be simple?
Even
Isn't it?
companies, there have been so many changes, no? They have brought in a lot of changes afterwards also, rules and this way. Sir,
You must have read one thing about the law. More the laws,
More the flaws.
पढ़ा है कभी?
us,
More the laws, more the flaws.
more the flaws.
जितना ज्यादा elaborate आप law बनाओगे उतना ज्यादा loopholes उसमें मिलेंगे, है ना? तो वो जो मैं आपको एग्जांपल दिया था, worst example is Income Tax Act. For how many years they have been amending it regularly? Since 1962. Like 38 years there and 22 years here. For 60 years they've been amending on every day. Still they are not able to plug all the loopholes. Why? Anyway, that is a long discussion story. So let us proceed further. So this part is clear. So you have to draw this chart again. That will be much more elaborated, but then again you don't need to refer this. Now coming to regulation rule number 4, this says application for the grant of license. Even if you don't read it, it's okay. It says a person may make an application for grant of license, certificate, script, or any instrument. So is it talking about the special license?
No,
This is different. This is talking about the different type of licenses. For example, the advance authorization or DFIA scheme or the EPCG license. So those kind of licenses it is talking about. Certificates or script or instrument bestowing financial and the other benefits. So as of now, we have scripts as well as other instruments bestowing financial benefits. Those are in the name of road TEP. So application is required to be made. And as of now, as far as road TEP is concerned, the documents filed for export, that itself shows whether it is under road TEP scheme or not. No separate application is required. But other than that, certainly application is needed. Rule number 5 talks about application, right? Or application fees. This is every application for license, etc., shall be accompanied with the fees specified in the policy. But schedule is there and schedule has been withdrawn. This is schedule rule number 5. It says it is omitted. Can you see this line?
Yes.
Right. So schedule was there and it was omitted since 2015. So as of now, there is no fees. Now, here from begin the important things. Conditions for license, certificates, scripts, or instrument bestowing financial or fiscal benefits. It shall be deemed to be a condition. What it says?
Condition.
Deemed. Deemed means it is implied, presumed. Deemed to be a condition for every license, certificate, script, of the instrument bestowing financial or the fiscal benefits for export that no person shall transfer or acquire the transfer. What it says? No person shall transfer, acquire, etc. license certificate. So it is simply saying non-transferable, right?
Yes.
But, except in accordance with the provisions of the policy. So I told you something is transferable. What is transferable?
Scripts.
FIA.
Script.
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 Scripts are
Script.
transferable. Scripts are transferable. License not transferable. Right? Other incentives are not transferable. Goods imported against the license are not transferable. But scripts are transferable. So that is given except in accordance with the provisions of the policy. So prima facie, nothing is transferable. So this is, no person shall transfer or acquire by way of transfer any license, certificate, script, or an instrument bestowing financial or fiscal benefit issued by the licensing authority except in accordance with the provision. So whatever is listed herein, except the scripts which are issued under FTP. In FTP are also under which chapter? Under which scheme? Under which scheme?
Export from India scheme scripts is there.
SEIS, Services Export from India scheme.
Yeah.
MEIS has been replaced with
RoadTap.
RoadTap, right? So scripts are there only in relation to export of services. So scripts are available under SEIS. The number 2 says the goods or services technology or export of which the license certificate is granted shall be property of the licensee at the time of export. So when we say property of the licensee, what does it mean?
Can be transferred.
Hmm?
Property sold. It can be transferable.
When we say for everything in relation to that license or those things, he will be responsible. When he is the owner of that, so it is being said that it is his property. So goods or services technology, that is his property. So for anything important, anything going wrong, he will be held responsible. That is his property until the export takes place. So once export is completed and legally title is transferred, then he is no more the owner. But until export is complete, right? So it is at the time of export. So once export is complete, then he is no more the owner, title gets transferred. Number 2, the licensing authority may issue a license, certificate, script, or instrument bestowing financial assistance subject to one or more of the following conditions, namely. Now, what is the difference in 1 and 2? Simply read the headline clearly and you will find the difference. यहाँ पर क्या लिखा है?
Fiscal or financial benefit?
No. Read what is highlighted.
Implied
Those
condition.
conditions are always there.
Yes. So whatever is given in sub-regulation number 1, those are always there. In sub-regulation number 2, what is the language?
May issue.
The licensing
Depends on the
authority
condition.
may issue subject to one or more of the following conditions. So those conditions, again, 2 conditions are there. Those may be there, may not be there. But that will depend upon subject to or the document which is issued. So that the goods or services technology covered by the license, certificate, script, or instrument bestowing financial or fiscal benefits shall not be disposed of except in accordance with the provision, the policy, or in the manner specified by the licensing authority in the license, certificate, script, or the instrument bestowing financial or fiscal benefits. So when specifically talking about EPCG, so when the goods are imported and the EPCG license is there and the export obligation has been fulfilled, then even for transfer, certain conditions are applicable. And those are there in the policy. So there, prima facie, there is export obligation discharge. It doesn't mean that now you are free to transfer the goods to anybody. Still, there is a procedure given under the policy. Then further it says that the license applicant for the license, certificate, script, or the instrument bestowing so and so execute a bond. Bond की जरूरत क्यों पड़ रही है? Bond की जरूरत कब पड़ेगी?
To safeguard the interest of the government.
Safeguard the financial interest of the government, right?
Government.
So whenever goods are allowed to be imported without payment of duty, any example where goods are allowed to be imported without payment?
Advance authorization.
Advance authorization, one thing, right? So when the goods are imported, the advance authorization, there is a minimum value addition obligation, there is export obligation, right? I'll give you another example so that you can
IGCR,
correlate.
sir.
Hmm?
IGCR rules.
IGCR rules. Okay. So when goods are imported only for the purpose of repairs and maintenance, what happens? Whether any duty is payable on that or not? Goods being imported only for the purpose of carrying out repair, maintenance, reconditioning, etc.
Condition of period is there. Otherwise payable.
Otherwise,
Duty is to be paid.
what is that condition? The condition is actually, this is covered under section 20 of the Customs Act. So that says that prima facie duty is applicable. But when those are being imported only for the purpose of repairs, maintenance, reconditioning, etc., and if a bond is executed, that the goods will be returned within a period of
1 year.
1 year after carrying out repair and maintenance, and the goods will not be used in India, then those are allowed to be imported without payment of duty, and for that bond is required. For that, bond is needed. So bond is for two things. Number one, the goods will be re-exported after repair maintenance within a period of 1 year. Number two, after repair, those will not be used in India. If there is a violation, the bond will be executed. It means duty plus interest plus penalty, everything will be charged. So whenever the facility is being given, at the same time, bond is also taken. Okay. So if you remember, we talked about that settlement commission may settle the case regarding the failure to fulfill the export obligation. Remember that? Right. So when there is a failure and the bond is likely to be executed, matter can go for settlement. Okay. So in the settlement, what happens? What do you understand by the word settlement? Generally asking, what do you understand by the word settlement?
Sort of a compromise or
satisfaction होती होता.
Anybody who's dealing with the indirect taxes otherwise?
Sir, win-win situation. Win-win situation for both the parties.
It is a win-win situation, but how? So whether liability is reduced under settlement or not?
No.
What happens in settlement?
It depends on case to case.
Settlement is the standard thing. इसलिए तो मैं पूछ रहा हूँ. Otherwise तो बात करके खत्म करके निकल जाते हैं आगे.
Penalty can be reduced.
First thing for settlement. Listen carefully. Number one, there should be a show cause notice. And notice for demanding the duty, interest, etc. Number two, the amount in that should not be less than 3 lakhs. Right? Minimum requirement. Then the person pays that amount. He is accepting the liability, then he pays the amount. And he is required to make the full disclosure. ये टॉपिक आएगा बाद में भी, केवल समझ लो, मैं सब बाद में नोट कराने वाला हूँ. Just understand what is the concept. So number one, there shall be a show cause notice. Number two, the demand should not be for less than 3 lakhs. Number three, the person accepts a liability which is minimum rupees 3 lakhs. Number four, he pays that amount. Number five, it makes a full disclosure. Then he goes to the authority. Now I want a relief against any further prosecution and penalty. So full disclosure, full discharge of liability. No reduction of liability at all. But When the settlement is done, settlement is full and final. After that, there is no appeal. And it is binding. Settlement is binding. So settlement is good for department that there is no further appeal for. It is good for the assessee also that there is no further appeal. Matter ends. So when a person goes for the settlement, he should be mentally fully prepared that I am going to put an end to the subject matter. And if the liability increases, I'm ready to pay that. Because if it is not paid, it will be recovered. Right. Plus further penalties will also be there. So settlement is a different concept. It will not be used in common sense. It will not be used as a general English. So this is not a case of compromise. Department is also not compromising. Assessee is also not compromising. He is required to make a full disclosure. He has to discharge full liability. Then only there is a settlement. And settlement means only one thing. He is given a relief against the prosecution and penalty. That is called settlement. Okay. So I hope you have got what is the meaning of the settlement. So settlement is a different concept. Next. Again, it shall be deemed to be a condition. Again, some deeming conditions are coming. So in sub-rule number 1, there are deemed conditions. In sub-rule number 2, those are specific conditions. Again, it is coming. Some deemed conditions, some more deemed conditions are there. No person shall acquire transfer of any license, certificate, description, etc. by the licensing authority except in accordance with the policy. This is a duplication. It is already mentioned there. Then number B says the goods or services technology for import of which a license, certificate, description, instrument, etc. is granted shall be property of the license. This is also duplication. So these 2 points are duplication. Then we have some more things. This is something new. So when the license is given, the license is authorizing only for the new goods. So license, certificate, script, etc., whatever is granted shall be new goods or services technology unless otherwise stated in the license. So second-hand goods cannot be imported against a specific license unless otherwise provided. Okay. So this is already said unless otherwise stated. So there are certain categories for which second-hand goods can also be imported. Say for example, second-hand DG sets allowed to be imported against a license. Even spare parts of the machineries repaired abroad, refurbished, those are allowed to be imported, but at least 50% of the life should be remaining condition. So all that we are going to see in the policy. So unless otherwise specified, the license shall be used only in relation to new goods, not for second-hand goods. Then any goods or services of the technology covered by the license, certificate, instrument, etc. shall not be exported without the written permission of the Director General. So whatever is being imported. Now, if you import some raw material, what for it is being imported? For manufacture of export goods, right? And by chance, if the person importer is having a good market for the raw material itself, can he export that material? He cannot without the permission granted, because then it is a violation of the condition. The license is given for the import of the material for being used in the manufacture of export goods. And here the person is carrying on the trading. It is a violation of the basic condition. So that's why the goods cannot be exported, which are imported against the license, etc., except without the written permission of the Director General. So it may happen that goods are imported against advance authorization, and for some reason, the export contract is reduced partially or totally. Now the goods are not capable of being used, so those can be exported. But for that, what is needed? Written permission of the Director General. Then any person importing goods or services from United States of America in accordance with the terms of Indo-US Memorandum of Understanding of Technology Transfer shall also comply with all the conditions. So no specific benefit for that thing. So this point is not relevant. In general, whenever any kind of license or script, etc., is issued, that is a property of the person, that is non-transferable. Even the goods imported against that, those are also not to be transferred unless specified otherwise. And even the goods also cannot be exported without the permission of the DGFT. So this rule number 6, you need to summarize. Okay. Then this is again a long list on what grounds licenses can be refused, cancelled, or suspended. So this is a case of refusal. When the license, etc., can be refused, and then we have another. Next is amendment. Then here we have the list of suspension of the license, suspension and cancellation. Okay, so regulation number 7 is only about what are the grounds on which it can be refused. Just list down the reasons. The applicant has contravened any law relating to customs or foreign exchange. Now, this is one-time disqualification or permanent disqualification. Sujata, what kind of disqualification is this? One-time or permanent?
It seems permanent.
Yes, it is. It is serious. Right. So if the officer gets stuck up, you cannot challenge his decision. Even one contravention of the for FEMA, violation under FEMA, and this license suspension it can be permanent disqualification. Right. So if you remember, those who are already into export business, they know that the declaration is required to be filed within the how much amount is required to be is expected to be received and within how much time. The time for realization of export proceeds is required to be submitted. Know that? No. So those who are aware of, and those who are not aware of, just understand that when goods are exported, a declaration is required to be filed regarding the time within which the export proceeds will be realized. That is a requirement from FEMA. And the banker is going to keep an eye whether you are realizing that amount within the specified time or not. And if not, it is the responsibility of the banker to inform the RBI. And RBI will require the person either to get the money or to get back the goods, unless for special reasons it is waived off. So if for any reason, if the export proceeds are not realized and it is not waived off by RBI, the person is going to be permanently disqualified. Right. So it is something serious. Now, the application for license certificate description instrument, this is not substantially conform to the provisions of these rules. So this way, all the ground, the application for document supported contains any false or fraudulent misleading statement. What is given in the information? Something false or fraudulent or misleading. Then it is decided by the government to canalize the export of goods or services or technology. What is the meaning of canalizing? Are you aware of the concept of STE?
Trade trading.
State trading enterprises. State trading STE. So foreign trade policy authorizes the government to create a monopoly in relation to certain imports and exports in favor of state trading enterprises. It means any import or export of that particular commodity or article will be only and only through state trading enterprise, that is called canalizing. Right. So even if the license has been issued to somebody for import export of some article, but tomorrow government decides that this article is going to be canalized, then even if somebody is holding a license, it will be suspended. This is Act. No, we are not talking about the Act. So canalizing the export, import, export the goods, etc., and any action Yes, here it is. Any action against the applicant for the time being pending. Now, what is the word used? It is not saying that action under which section, under which law, under which provisions. This is any action against the application is pending under the act or the orders. So even some small issue may result into license being suspended or being refused, that until all the conditions are fulfilled. Then, this is something crucial. Now read this. Lots of people use it as a way out, but this will also be difficult. The applicant is or was a partner in a partnership firm, including LLP, or is or was a director or a proprietor of a proprietorship firm having controlling interest against which an action is for the time being pending, or the rules are made there and that. So this is commonly believed that if today somebody has committed an offense, tomorrow he creates a partnership firm with somebody else, and then he carries on a business again. No, that will not be there, because it says applicant is or was a partner. Even if he creates a company, still it is going to be the same. So this is a very strong blockage of the loophole. Right. So he can still do that, but without involving his own name. Okay. So if the applicant is or was a partner of any firm, or he is or was a director of any company against which any action is pending under this act or the rules. So Nehaji, what will you suggest in this situation?
Tom, Dick, Harry.
Or a spouse?
Yeah. No, spouse nahi.
Spouse
Tom,
nahi.
nahi.
Your spouse is also TDH.
No.
चलिए आगे बढ़ते हैं. The applicant fails to pay the penalty imposed under this act, or the applicant has tampered with the license certificate, etc. So all these are, it's a long list of the reasons on which the license can be refused. This is a refusal. So until and unless all the things are rectified, because of which the license is being refused, it will not be issued. Right. So this I'm leaving for your homework to complete. Regulation rule number 7. All the grounds on which license can be refused. Okay. And if you find time, you can continue reading these rules. Otherwise, in any case, we will continue in the next lecture. We'll finish off also this, all the things.